I'm Rob Hassett. I'm a lawyer in Atlanta. I practice in the areas of corporate technology and entertainment law. I also manage the internetlegal.com and tellmesomethingidon'talreadyknow.com websites. Today I'm going to talk a little about the recently implemented Six Strikes Anti-Piracy program. It was implemented in February of this year, 2013. It sort of was a replacement, in a way, for the lawsuits that the RIAA was filing back in from 2003 to 2008, which caused a horrible PR problem. It involved a lot of what people considered a shakedown when they would demand $3,500 or $4,500, and the owner of the IP address had to either pay that money or hire a lawyer to defend them, which would cost a lot more. It also turned out that a lot of the people that were sued, or some of the people that were sued anyway, were not really sharing files illegally over peer-to-peer networks. But they were, for example, neighbors that could, back when the security wasn't very good, that were getting into their using their IP address to share these files. But whatever it was, it was very expensive. From 2006 to 2008, the RIAA supposedly spent $64 million to collect $1.4 million, so it wasn't workable. And they did this. They started this talking to ISPs about this program, which really just amounts to the content providers notifying through their representative organizations, the ISPs, that are parties to the program, that their subscribers are illegally sharing files over peer-to-peer networks. And the ISPs notify their customers, and the customers, first they're just given an educational notice, it's called, and then it escalates from there. But essentially, basically, almost all customers are going to stop the illegal file sharing when they get the notice. So it's a really good thing. It's much better than suing. And with suing, you can, no matter how many, you can only sue so many people, whereas with the notice, you can send notices to lots more. And I think it's a great program. Are there flaws? Yeah, there's a few flaws in it. Liz Wheeler, who's another entertainment lawyer here in Atlanta, mentioned one to me, told me about one. She had read that people that the ISPs were sending the notices to the email addresses of the ISPs that provided to their customers. The problem with that is that most people don't use those addresses, and a lot of people weren't getting the notices, but I'm sure that's being remedied. I'm sure they know that they need to mail them just like they mail their bills, and their subscribers will get those. Another problem is only people who only people who share the files illegally over the network are subject to being found out about. If you just download, nobody's going to know you did that. Because if the only way they could find out your IP address that you were people downloading is if they downloaded, if they provided the files themselves, it's what's called a honeypot. And if they did that, it would be they're authorized to provide the copyrights. And if they did that, the people that downloaded wouldn't be doing anything illegal. It didn't work nobody did that with lawsuits. None of those people got sued, and they're not being subjected to these notices. Another problem is that not all ISPs are participating. The 5 of the largest ISPs are participating. Those are Time Warner, Comcast, AT&T, Verizon, and Cablevision. But many of the largest aren't, including Cox Cable, Charter, and CenturyLink. And none of the 100 small ones are, and no foreign participants ISPs are participating. But that should be remedied somewhat over time, and they can only can try to convince the ISPs to participate. Can't make them. If you want to know more about the program, it's being administered by the Copyright Information Network in Washington, and the domain address for that organization is copyrightinformation.org. If you have any questions from me, you can email me at rob@internetlegal.com.